Representative Whalen. While we are looking for Representative Wills, I believe he's in another committee as well at this time. Would you be willing to start out on, since you're one of the co-authors?
Mr. Chair, members of the committee, I am not prepared to make any remarks on this.
I believe Representative Zerwas will give you a hand.
It's 2766. It's the DWI. You're the only other co-op.
Okay. Thank you, Mr. Chair, members of the committee. I will confess that I don't believe I'm an expert on this, but also I just wanted to clarify. I was just chatting with some of the folks that were working with me on the previous bill that it was laid over.
That is laid over.
Making sure. So the reason that I co-authored this bill that is before you today is that there's actually a member from my church came to me and said that there was a good friend of theirs passed away because of some intoxicating substances that were I believe in a car situation, and right now our statutes don't regulate that. And so this bill, my understanding, is to address those issues and help ensure that when we're defining intoxicating substance, it includes those specific substances that led to the death of that good friend of hers. And so I found out that Representative Wills is actually the representative.
Your list of testifiers.
Representative Wills is actually the representative of the family, like in the community, that was in the community where it happened. And so she had been approached previously, and I said I believe it's a good bill and would like to co-author. With that, I don't have much more to share as far as my involvement with this bill, Mr. Chair, but there are some testifiers here, and I'm happy to answer any questions from members.
There's also the A1 amendment. Amendment number is the A1. The chair will move the A1 amendment. All those in favor, or say aye. Aye. This will be getting the intent of the author described, and I guess we will start with the first testifier. I believe it's Clay Kendhammer. I wonder. What about is David Bernstein here? I have a feeling they're in another committee at this time. Lieutenant Don Morrows.
There we go.
Morning, Mr. Chair.
Good morning. Could you please state your name for the record and continue?
Don Morose. That's M-A-R-O-S-E. And I'm just here today to just quickly to say that this bill is going to go a long way to assist law enforcement in removing impaired drivers from our road. Currently, we have what I would describe as a loophole in the law that does not allow for some enforcement and prosecution of some drivers who are impaired on things that don't currently fit the definition of the law, and this would go a long way in helping kind of close that loophole or at least give us more tools in the toolbox to assist in removing those impaired drivers.
Thank you. And the Representative Wills is now here to finish. For the committee, just as well, the chair is going to move to lay the bill over for possible inclusion. And we've already attached the amendment.
Thank you, Mr. Chair. So I apologize. I was presenting a bill in tax committee and came right down. So I know my legislative assistant is making sure that the rest of the testifiers can get down here for the hearing. And you already gave your testimony? Thank you. So this bill was brought to me by a constituent, House File 2766, and the constituent is expected to be here to testify today. His name is Clay, and he'll tell his story. But what happened in light of the situation that happened with his brother and his brother's friends passing away with a car accident that happened in Wisconsin and brought about a court case here in Minnesota. And we realized that if the accident had happened here in Minnesota, there would have been no way to prosecute under our current DWI law. And so we've been working with the DWI task force and several other stakeholders to craft the language and make sure that it addresses that situation. And what's currently in our state law is the OSHA list for hazardous substances. And the reason we decided to go away from the OSHA list is because a few different reasons. One of them is currently it's an itemized list, and as new chemicals or substances are being discovered, they may not be on that list. And the reason we didn't want to just add a difluoroethane, which is the substance found that is not on the list, to just add that would mean adding any future chemicals through the legislative process, and that can be a cumbersome process. And so we wanted to do a broad change that would allow us to address these situations without having to come back to the legislature multiple times. So changing the language to intoxicating substance that impairs the central nervous system or impairs the human audio, visual, or mental processes addresses it in a more comprehensive way and helps out our law enforcement and prosecutors when they're dealing with these cases. So another reason that we wanted to go away from the OSHA standard is because it doesn't deal with driving and with the DWI situations. It actually deals with labor and workforce situations. So it wasn't the most accurate or applicable method to begin with. So you have in your packets, at least you should have, several letters of support for the bill from the DWI Task Force, the Minnesota County Attorneys Association, Minnesota Police and Peace Officers Association, Minnesota State Patrol Troopers Association, Mothers Against Drunk Driving, Minnesotans for Safe Driving, the Department of Labor and Industry, the South Lake Minnetonka Police Department, and the Household and Commercial Products Association. So there's several stakeholders who have been involved in the crafting of this language and are very familiar with these types of situations and are in full support of this bill. So with that, I would be happy to have any additional testifiers present their testimony at this time or answer questions.
Have your testifiers arrived yet?
I don't know if we have any in the audience.
Please introduce yourself for the record and continue.
Well, Mr. Chair, my name is Jeff Tate. I am the Chief of Police for the City of Shakopee. I'm a proud participant in the state's DWI Task Force and a director with the Minnesota Chiefs of Police Association. I'd like to express our Chiefs of Police Association support for House File 2766. As you heard, a loophole currently exists. Not all substances that impair driving are recognized the same under current law. Consequently, not all impaired drivers are treated the same. This proposed legislation fixes that loophole and would keep us from coming back year after year to add additional substances to the list. OSHA's list of hazardous substances is too small and hasn't been effective. Regardless of how impaired someone might be, we can't charge unless it's on the list. For example, someone could be on dust-off glues or bath salts and maybe show much more higher signs of impairment than someone who is a .08, yet the punishment is not the same. Striking references to hazardous substances or OSHA's list in general is an important step forward. These substances are tough to deal with. Synthetics are always evolving and are often available just by simply clicking one's keyboard. We're always playing catch up on these substances. Change one molecule and it comes off the list. The burden is still on us to prove that someone drove impaired and what impaired them. I think it's important to remember that this is not just about punishment, but this proposal will also help individuals get greater access to valuable court services, including education, monitoring, and treatment. So the Minnesota Chiefs of Police Association again supports this bill because it closes a current loophole in the law, improves public safety on our roads, and provides better opportunities for intervention and treatment. Thank you.
Thank you. Go ahead with your next testifier.
Thank you, Mr. Chair. I'd like to introduce Clay, who is the constituent who brought this situation to Senator Greg Clausen and myself to get this addressed.
Welcome to the committee, and if you could please state your name for the record and continue.
My name is Clay Kendhammer. Thank you for allowing me to testify. I apologize for being a little late. I think I misread the email. But on July 13th, 2017, Brian Riddell, Jeremy Burcham, and Adam Kendhammer, my little brother, died in a ditch along I-94 in Wisconsin, about 40 miles from the Minnesota border. The personal belongings they had packed for a weekend at a cabin were scattered along the road. The car that they were riding in was unrecognizable and burning as people drove by and stared. Brian was so badly disfigured that his mother never even got to look at him again. They were spared no dignity. This is the reality of my brother's death. They were killed when my brother's car was hit head-on by someone driving the wrong side of I-94 shortly before 5 o'clock on a Friday afternoon. The driver of the other vehicle, who of course survived, was found to have multiple spent cans of Ultra Duster in his vehicle, which he had huffed to get high from a chemical known as DFE. In Wisconsin, DFE is considered an intoxicant. Operating a vehicle with DFE in your system is covered under the state's DWI laws. That's not the case in Minnesota. Had this happened 40 miles to the west, the driver would have been charged with careless driving. The bill that is being presented is designed to correct this. When this bill was introduced and presented to the Senate committee, the dissenting view was given by a representative of the Defense Attorney Association. His hypothetical concern was that the law might be used unfairly to prosecute the innocent, specifically someone who had drank a can of Diet Coke and now had caffeine in their system. That seems like a plausible argument. All you would need is an officer who thought it was his job to look for caffeine users, a prosecutor who would go along with it, a judge who would allow it, and the abolition of the appeals process. My brother's killer was found at the scene, in the vehicle. There were scores of eyewitnesses. He had a history of impaired driving, no license or insurance. After a search warrant was granted by a judge, his blood was tested and he was found to have DFE in his system. And yet this open and shut case remains unresolved because this type of conviction being sought is just not that easy to get. Maybe caffeine concerns are not all that plausible, and maybe that wasn't really the reason they were objecting to the law, but like I said, it was hypothetical. My experience is based on reality, and the reality is that law enforcement is in a race against the world, trying to keep pace with the different substances that people are using to reach a longer, more intense, and cheaper high. Failure to act now will lead us right back here, trying to play catch up as each new substance gains popularity and leave lawmakers trying to explain to another victim's family why they're being denied justice. Thank you.
Thank you. Any other testifiers?
I don't know if we have any more in the audience or if they're still on their way down.
Mr. Chair and members of the committee, I'm Nancy Johnson. I represent Minnesotans for Safe Driving. We believe it's imperative that every driver is not impaired by any substance. Unfortunately, every year there are multiple new intoxicating substances being developed illegally for the purpose of getting high and that are not on any list and are not defined as a controlled substance. Plus, there's everyday substances that can be used to get high that are made for other reasons, such as dust off, compressed air, bath salts, gasoline, paint. If a substance is not listed as a part of the law, the driver cannot be charged with a DWI and may continue to use it because they cannot be prosecuted and treatment cannot be mandated. It would be difficult and dangerous to wait for legislation sessions to add new substances every year, while the substances out there are causing crashes and fatalities. A stop for DWI has been a wake-up call for many drivers that haven't had to face their addiction or what they might consider themselves impaired. This bill eliminates the hazardous substance listing. That is a list made up for protecting the employee from the dangers of hazardous substances that can cause health issues to the employee, but is not appropriate for the types of substances that cause impairment on the highway. Instead, the term intoxicating substances with a new definition will take its place and cover the array of substances that are now and ones that will be developed. We do not want anyone on our roads or behind a snowmobile, recreational vehicle, a boat under influence of any intoxicating substances. So we really want this passed. Thank you.
Thank you. Representative Howe.
Thank you, Mr. Chair. And I think you're absolutely right. This needs to be done. I do, and we need to tighten this up. I do have some concerns, and maybe you can work on this. Maybe you've already had this discussion, but I'm a little concerned about taking out the knowingly. And that's my only concern is that someone may be exposed to a chemical either at work as a firefighter or someone that works in a plant and may not actually know that they're impaired on a substance, even though I know that that's still wrong. I'm just a little bit concerned about casting a wide net. Maybe you've already had this discussion. That's the only thing that strikes me is when we struck the word knowingly throughout the statute. So if you can speak to that and maybe ease some concerns.
Representative Wills.
Thank you, Mr. Chair, and thank you, Representative Howe. And I appreciate that. It's a very valid question and something that was addressed in the Senate hearing as well. And while I understand the concern, this is something that I spoke with the folks on the DWI task force and several prosecutors. And the reason why we want to strike the word knowingly is because it's basically impossible to prove that someone knowingly consumed a product. And there's already a self-defense option where you can prove involuntary intoxication. So that is available to someone if they feel that they didn't know, that they weren't aware that that was going to affect them that way. So there's a process and by which that can be proven, that it was involuntary. And the other aspect of knowingly is the way the language is crafted is it speaks about being impaired. And your question to whether it could happen secondhand. And we address that as well in the sense that none of the prosecutors I spoke with have ever experienced a secondhand type of impairment. And especially with these types of products, you really have to be intentional about having that material up in your face to inhale it. And it's practically impossible to have secondhand intoxication from those materials.
Representative Howe.
Thank you, and thank you for that explanation. I was more, and I know knowingly, to me, we should never put it in any legislation, but I was thinking more going with the intent, that you did it with the intent to get high, but that's a good explanation. Thank you.
Thank you.
Representative Grossel.
Thank you, and I agree totally with this bill as well, but the knowingly part is also one of my concerns. Working as a narcotics officer, we used to have to strip a lot of marijuana plants and get them ready for BCA for analysis and so on. And every now and again, you'd feel a little bit, not intentionally, but you'd feel a little bit loopy after you're done with your job. So as not being one who smoked marijuana or ingested marijuana, but it had an adverse effect on me unintentionally. So it would be something if you're willing to discuss this further. I know a lot of prosecutors, you don't run into that a lot, but there are people that work in paint shops, auto body shops. Should they become impaired unintentionally? Those are the types of things. So if this can be a discussion that can be had later, that'd be great.
Mr. Chair?
Representative Wills.
A couple other comments, and I appreciate that, Representative Grosso. My thought is that what you're describing wouldn't be to the level that this bill covers, that they would have to be impaired to the point where they wouldn't be able to function driving a vehicle or a boat and that sort of thing. So feeling a little lightheaded, I think, is very different than what the bill addresses. But it's a valid concern, so I appreciate you bringing that up. And then another point, as far as the knowingly, is currently, if someone is under the influence of alcohol, which is not addressed in this language, it's a separate section of statute, someone could say, well, I didn't know I was that drunk, or I didn't know I had that much in my system, but yet we still prosecute because that much was in their system. So the word knowingly is not used in that situation or in those statutes, and I think it's fair to address it and treat it the same way here.
Representative Uglum.
Thank you, Mr. Chair. To Representative Grossel's concerns and things, I guess I would concur from the fact that there's a difference between overexposure in a paint shop or factory setting and things like that, and OSHA's guidelines have, their threshold volume limits that you cannot exceed and things, and most commercial companies and everything else are regulated by that, and they have air makeup systems and so on and so forth. In my paint factories, occasionally I would have guys that would huff solvents, which is pretty easy to do in a paint factory, but they really had to go at it and all that. So you really have to intentionally try to get high, and as far as incidental exposure, I think it is pretty rare. Thank you.
Any public testimony on this bill?
Mr. Chair?
Representative Wills, any
I
final
know I
comment?
had a few more testifiers on their way. I don't know if they're in the room yet. Perhaps not yet.
Is David Bernstein here yet? That's the last one we have on your list.
I think so.
Mr. Chair,
Representative Considine.
I would tell the author that I think she's got me convinced, and I think we can go forward.
I do as well. I've actually had a situation involving a crash with a synthetic chemical that was not on the list at the time, and I am very thankful you're bringing this forward because this is a very serious situation that we do need to address. So thank you.
Thank you.
Any final comments?
I'll have to let David know he shouldn't have been late. Thank you, Mr. Chair and committee. I really appreciate your time and attention and your excellent questions. I think this is an issue that needs to be addressed for our law enforcement and for our court system to be able to prosecute properly and effectively, and to keep our roads safer. And I know it's something that we don't want to do lightly or without making sure we're doing it correctly. So I really appreciate all of the stakeholders and all of the input that has gone into making sure that this is getting done correctly in this language. So I appreciate your support.
Thank you. And with that, I'll renew my motion to lay over for possible inclusion into the omnibus.